Hey, everybody. Welcome back to the Shanty. So I know we just did a Shanty, but we're back again. And we're back again because of my four favorite letters in the alphabet. ESTA. I hate those four letters and I never want to see them again, which makes it really, really difficult to write my name. But with that said, we're doing this for a couple of reasons. Number one, we're doing it because the 23rd of this month, you're supposed to have all this done. Now, the act has already gone into effect a month ago, but the 23rd of this month, according to Leo, you are supposed to have all this done and you are supposed to have announced to your employees what your new policy is going to be. We're also doing this because Anne Steen, who's here with me today, who you guys all know because she's been here with me before, has been keeping track of Leo's frequently asked questions. And every week or so, she runs a red line to tell us what's new. And this week, when she ran her red line, we discovered some new stuff that we didn't know, but that answers a couple of the questions that we've had. So if you guys have gotten policies from us, a lot of you have seen comments in those policies saying, we're not sure about this issue, or it's not clear what we're going to do on this issue. Well, we've got three of those issues dealt with in the FAQ. Now, Anne's going to give you some, I think we'll call it editorial comment on one of Leo's positions, at least. And I'm going to give you some editorial comment on one of them. But that's what we're going to talk about today. So this might be a little longer than normal because I'm blabbing on to begin with. But also we want to cover these things and make sure you guys understand at least what Leo's position is on these three issues. So let me start with the first issue. As you guys may or may not remember, ESTA has a provision in it that exempts from ESTA's coverage employees who, and I'm paraphrasing here, who can set their own schedule under a policy of the employer, and the policy of the employer doesn't allow the employer to discipline the employee if they refuse to work. So we got a lot of questions about, oh, well, that should cover my on-call employees, right? That should cover my on-call employees. Now, I've, from the beginning, taken the position, I'm not so sure about that. Well, Anne, Leo spoke to that issue, right? What did they tell us?
Yeah, so the LEO has kind of signaled previously that they thought this was really narrow. They did like a webinar where they said, this probably only applies to highly compensated individuals who are employees but choose their hours, may or may not apply to people who are per diem or on call. But they were a little bit on the fence about it. They have, in their most recent guidance, elaborated on their position, I guess we'll say, and have expressly stated that this exception does not apply to employees that are on call, flex scheduling, per diem employees, if the employer controls their schedule. So in other words, employees that, sign up for their own shifts are covered by the ESTA. So they clarified, they kind of put it out there fully in writing. Not on call, not flexible schedule employees, not per diem employees. If you're still controlling their schedule in some way, which we kind of knew this in a certain way because most of those folks have to sign up for a minimum number of hours, and the employer does exert some control over their schedule. But that's been put out there in bold text.
Well, and then so what you're saying, Anne, is that I was right.
Yes, I am. Yeah.
So
unsurprisingly,
what you guys need to take away from this is that your on-call employees are covered.
Yeah.
And Leo gives some examples in their update about how on-call and flexible schedule employees can use sick time and when they can use it.
Yep.
But they are covered. You're not getting out of it. This is, as I thought from the beginning, a super narrow exception that just generally isn't going to apply to on-call or flexible schedule people. So keep that in mind as you're going forth on your policy. So that's number one that they cleared up. And Leo cleared that up pretty well. I mean, they cleared it up. That's their position on it. All right?
Yeah.
So the next issue we've had is because of the timing of this ridiculous thing and not having it start at the first of the year and having it start on the 21st of February, there were a lot of questions we were getting about, okay, what happens between, I want to use a calendar year. What happens between January 1 and February 21 to the time off that I'm already giving my employees.
Yeah.
Can I count it? And Leo spoke to this too, Anne, and I know you've had a lot of questions from clients about, okay, what happens in the interim and what do we do? And I know you've been dealing with them in a certain way. We've kind of all taken the same position on that. So what did Leo say about that?
Yeah, this has been one of the most interesting kind of open questions, right? From the beginning, this act, the previous version of it was supposed to become effective on February 21. And then, of course, we got the amendment overnight that was immediately basically effective on February 21. So what do we do with time that we've already provided to employees, right? There was so much uncertainty from January 1 to February 21 about what was going to happen with this act. And a lot of employers just executed their usual procedure to provide time off on January 1. So now that we know this act is in place, can they take credit for any of the time that they already gave to their employees towards this either 72-hour or 40-hour paid leave obligation, right? LEO has finally sort of staked that you put their position out there on this only a few days before the reporting deadline. And they have said that employers may use or may take credit for pre-existing time they provided to employees, but importantly, only to the extent that time was still in the employee's bank or available to them as of February 21, 2025. So if you had an employee, if you gave your employees time on January 1st, let's say you gave everybody 80 hours and somebody has used up all of that time before February 21, the LEO takes the position you need to provide them with an additional prorated bank of 72 hours to get them to January 1, 2026. In other words, you need to give them more time if they used it all up. Now, conversely, if you had another employee who also received 80 hours on January 1st, but has used 0 hours and has 80 hours left on February 21, 2025, the LEO takes the position you don't need to give them any more time. They have enough time to meet the obligations of the Earned Sick Time Act to get them to their next, front-loading date of January 1, 2026. So you can see how this may lead to some disgruntled employees, right?
I'm actually thinking about the disgruntled employers here, not the disgruntled
well, yes, but employers who have to deal with their disgruntled
correct,
employees,
correct.
right? Yeah. So if employees have used a lot of time, they're actually going to get more time under the LEO's interpretation. And if they haven't used their time yet, they may get no time, right? Which seems sort of unfair in a way. But that is the position the LEO has taken. They have finally sort of, made their position.
So once again, Leo in their infinite wisdom has said, all those really good employees that save their time and come to work and do what you want to do, they're all going to get penalized. And the guy who used all his vacation up in January, he gets more time. And that to me seems completely ridiculous. But that's what Leo is saying, just so you know, okay? And by the way, some of you that I represent, that I, at the beginning of all this, said, we don't really care what Leo is saying because it's the courts that are going to decide this. Except for that's not the case anymore, right? Because when they amended the statute, Leo is now going to decide this because the employee has to file their complaint with Leo. They can't go to civil court anymore.
Yep.
So now we do have to pay attention to what Leo is saying, which brings us to the next and the last question, and the one where we're going to get a lot of editorial comment from Anne, because I'm going to tell you right now, Anne won't step out on a limb like this, but I will. I think Leo is dead wrong here. They are dead flat wrong, in my opinion. And that comes to the issue of this 120-day waiting period that's now baked into the statute. In other words, if you have a brand new employee, the statute says, and the language that the statute uses, Ann will correct me if I'm wrong, is you can make a new employee wait 120 days before they can use any accrued earned sick time. So Leo has taken a position on that from the beginning, which we thought was not correct. And Ann's going to tell us why they've taken that position and what it is right now.
Yeah, so basically, the LEO has taken the position that only employers that are using the accrual method can require this 120-day waiting period. So they have taken the position, in other words, if you're a front-loading employer where you give everybody their time right up front, you cannot require them to wait 120 days as a new hire to use that time. They need to have that made available to them immediately. Now, this is just such an interesting position to take. The act does say, okay, in their section describing front-loaded time, that it needs to be available at the beginning of a year for immediate use. Now, year is defined elsewhere in the act to mean the employer's benefit year. So, like if you use a January 1 to December 31 benefit year, or if you use an anniversary benefit year, that would be your year for purposes of the ESTA. It does not say front-loaded time needs to be immediately available at the beginning of an employee's employment, which is, kind of elsewhere in the act, it's described as commencement of the employee's employment. It only says it needs to be available for immediate use at the beginning of a benefit year. Now, arguably, if the legislature wanted employers to make front-loaded time immediately available to new hires, they could have so said. The other thing is
Well,
that,
and let me interrupt you just for a second. I don't
yeah,
want
go ahead.
flow, but I also want to point something else out.
Yeah.
There is a provision in this act for paying into a multi-employer benefit plan. So if you hire people from a hiring hall, right? And the legislature in that provision specifically said, if you pay into a multi-employer plan, you do not have, you cannot make the employee wait 120 days. So in other words, not only could the legislature have said, yes, this doesn't apply to or this does apply here, they could have said it specifically doesn't apply in this situation. And they didn't do that. They know how to do that. We know they know how to do it because it's in another provision of the act, and they don't. That, to me, is a good argument that the 120 days can be used whether you accrue or front load. And I think the court would find that too. But Leo's probably hanging their hat on the word accrue, right, Anne?
Yeah, right. But, again, throughout the ESTA, the word accrued is used to refer to both front-loaded time and accrued time. Even in the section that defines sort of front-loading time and how employers can do that and what it accepts them from doing, right? They don't have to carry it over, etc. It's referred to as accrued time. So clearly throughout the act, accrued doesn't mean only employers that are on the accrual method, right? It certainly isn't used that way. So it's very interesting that the LEO has taken this position. They clearly are not afraid to kind of put themselves out there on a limb, as you said, and extrapolate or maybe even, deviate from the language of the act. So
yeah, and I'm not afraid to put me out there either. I'm not going to speak for Ann or for Warner Norcross. I'm going to speak for me. I think Leo's wrong, but that doesn't mean you want to be the test case,
right?
All of our friends out there, because this is what Leo is saying, okay? And we're just telling you what they're saying, right? So if you have questions about that and you want to talk through it, obviously you're going to have to call us. So what else do we need to know, Ann? Anything at all, or does that cover the basics of the big stuff?
I mean, those are probably some of the major ones. Obviously we have to encourage you to read all the FAQs, right? As Steve mentioned, the LEO is the first enforcement mechanism now. So it's important to understand where they stand and how they're interpreting this and kind of what their position is. So.
All right. And so go out and read those FAQs. But really, if you have any questions, you should call us. Remember, we're running out of time. Now, I know most of you, and I know this because we have, apart from Ann, who's a very senior associate, and we don't even view her as an associate anymore, we have 4 younger associates who've been doing nothing but drafting ESTA plans for the last 4 weeks. So hopefully all of you have got all this done and you're all ready, and all we have to do is make a tweak here or a tweak there. But if you haven't done any of this, shame on you. And you don't have much time left, okay? So we got to get moving, all right? So give us a call with any questions you have, whether it's, hey, what do I do? Or, a little something on the margins here or there. We're happy to answer those for you. If we seem a little frustrated, it's because we're as frustrated with this as you guys are. After COVID, I didn't think we'd need to do this again where we didn't know the answers to stuff, but here we are once again, not necessarily knowing the answers to things. So thanks for joining us, Anne. Thanks for joining me. Anything before we leave?
Nope.
All right. We'll see you all next time.